Hi, my name is David P. Shapiro. I am a San Diego criminal lawyer, and I'm also the owner and managing partner at the law office of David P. Shapiro. My firm helps good people regain control of their future when charged with a crime. And today I want to discuss with you what happens when someone is under investigation for or charged with theft. Theft could come in many different forms. Theft could be petty theft, like shoplifting. Theft could be grand theft, which is an amount usually over $950. It could be property. It could be a vehicle. It could be jewelry. It could be services. It could be money. Employment theft, theft by employer, or theft by employee. There are so many different ways that people could be charged with theft, and particularly ways that people could be charged with theft in San Diego. But the underlying premise on what to do if you're charged with theft remains the same. And it boils down to, first, make sure whether you are factually innocent of the charge, meaning I didn't do it, or whether you did it, but you may have a defense, a legal explanation, or whether you did it and you are as guilty as the day is long. The underlying premise of what you can do to protect your case is as follows. First, do not discuss the case with the cops. Do not discuss the case with your friends. Do not discuss the case on social media. Don't do law enforcement or the district attorney or the city attorney's job for them. In any case, particularly in a theft case. If you're questioned about the amount of theft in question, okay? So you're asked a couple of questions. Hey, we know that you stole $25,000 from your employer. Let's say hypothetically you know that you did. You stole $11,000, not $25,000. So you think you're doing yourself a favor. No, officer, I swear it was $11,000 tops. Okay, so in one regard, you think you're this greatest negotiator in the world because you just shaved $14,000 off what the cops think you stole. But if the cutoff for theft and grand theft is a felony is $950, what have you really done? Nothing. Other than confirm the fact that you're now going to be proven guilty of grand theft. In many instances, solely because of your own admission. So that's one thing. Another thing you need to keep in mind if accused of theft is there may be certain defenses. There may be claim of right. Hey, I thought that was my property, or I was going to take it back from someone who took it from me, or I didn't have the wrongful intent. Maybe I forgot. I got distracted. Especially those of you with small kids. If you're in a store, kid starts acting up or needs something from you, your focus is going to be with your kid. It's not going to be on making sure that everything that I have in my cart is paid for, everything I have on me is paid for. But you don't have to go into all that explanation. Let the prosecution be able to prove your intent. Don't do that for them. The other thing you want to keep in mind if you're charged with restitution in a high amount is start gathering some money for restitution. If you're charged with theft in a high amount, you want to look at restitution. If you have the money to pay back, you want to start gathering that money. Talk to your lawyer about that. Because that could go a long way in facilitating a better resolution if you're ultimately going to be convicted of an offense. So, theft comes in many shapes, it comes in many sizes, but the common themes are the same. And one other common theme that I want to leave you with is make sure you hire a quality, locally experienced criminal defense law firm, whether it's my firm or anyone else's for that matter. If you are under investigation for theft, if you're charged with theft, if you need help and you want our help, we encourage you to give us a call. 619-295-3555.